a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
It's time for one of the most fascinating conversations in all of Melbourne in all of the week, and that is David Whiting offering you some legal advice. Good morning, David.
Good morning, Virginia.
You had a haircut.
I have.
It's not a lot to work with.
No. That's why the styling is just so important.
You are funny. What's the homework?
Alex from Chelsea rang. Alex had an interaction with the police and wanted to know what the process was for getting body cam
so
footage.
she wanted the footage, yes.
And the process, you automatically get it if you're charged with an indictable offence, and you also automatically get it if you are given a caution.
Right.
So
does
but
she
in the
fit the
event
bill?
that she wants it, we don't. I looked at the transcript from last week and we found that there was an interaction with police, but we didn't know where it went.
Okay.
If she has been charged, what she does is she asks the informant for a full brief of evidence, and they are required to give her the body cam footage.
Okay, but if it was just a little interaction that she's grumpy about but no charge.
If she wants to make a complaint about the police or
Behaviour.
or PSO officer.
Yep.
PSO officer, redundant, never mind.
Yes.
Then the
ATM
answer
machine,
is,
yes.
Yes, okay. Then you are able to get a copy of you're able to look at the footage.
You are.
Yes, she will get access if it's one of those, but it's not an FOI request. You can't get one for a Freedom of Information request.
And any interesting news to bring us?
There was a fascinating case in Western Australia. A couple owned a unit which they had in investment property, and there was the tenant from hell living upstairs in the same block.
What did they do?
Things like played loud music at 3 o'clock in the morning. When there was noise downstairs, they would thump the floor upstairs. So, in a sense, made the tenant from hell made living downstairs hell. And they
Just sounds great, doesn't it?
Well, no, I've had some clients with similar issues, but
I'm being sarcastic, so
Oh,
have
I'm sorry, I couldn't tell.
I'll stop it.
Yep. What then happened was they sold the unit, but they didn't bother to tell the buyer about the risks.
Right.
And the buyer then, having settled, sued, sold the property, losing money. So the buyer sued and made claims under the Australian consumer law, which were unsuccessful, but then made a claim that there was a material fact that ought properly have been disclosed and wasn't, and was successful in that proceeding. The difficulty is that the people who sold the unit had no money, the people who bought the unit had no money. So it's going to be one of those things where here's a nice judgment that turns on all of the issues, but absolutely everybody in it's a loser. But I would come along and I would expect that sooner or later there'll be a similar case in Victoria turning on the same kinds of issues.
Will the Victorian courts pay attention to what's been decided in a WA court?
Yes, they will. It's not binding on a judge here,
Sure.
but it's persuasive,
Yep.
And so you need to look carefully at the facts. The obligations here are in Victoria are contained in the Sale of Land Act, and says that a person must provide this material information, and if they don't, they commit an offence. But it's not a contract term with the buyer, which it is in Western Australia.
But is something like a noisy neighbour considered a material fact?
I think it depends upon the extent of the noise. So if you've got someone who has a party on Australia Day every year and nothing else for the rest of the year, I wouldn't have called that a material fact. But if somebody parties from Friday night to Sunday night and plays loud music 24 hours a day, I would say, that was very material.
Right. Gee, that's fascinating, isn't it?
So it will be, I think...
And good too. I mean, that sort of stuff absolutely should be disclosed. It's not just about, you didn't tell us that water was coming through the wall or there was a leaking pipe, but something like, the environment around that apartment is material.
Yes, I think so.
Yeah, good.
Yep, it'll happen.
Over to you. What help do you need? 1300 222 774. Peter in St Kilda, go ahead.
Good morning, David and Virginia. David, a query about adverse possession. I own a property in St Kilda, a small block of land. Apparently the fence is about 60 centimetres encroaching onto the person's property at the back.
So what you're telling me is your block is bigger than it should be. Is that right?
Yes, I am.
Yes. Yep.
And I was just wondering whether or not I've got any chance of mounting a adverse possession claim.
How long has the fence been there, Peter?
I think it's been there for ages, but I don't know where the...
Is ages more than 15 years or less than 15 years?
I think it's been there more than 15 years, but I can't prove it without contacting the people who own the property before me. I've only been there for 4 years.
What you want to do, Peter, is talk to the people who you bought the property from, who may be hard to find, and what you want to do is see whether you can acquire whatever adverse possession rights they had, and there may be documentation from the time that they bought which would indicate that the fence is in the current position.
Right. And what if I can't? Can't locate them?
Just settle in for another few years.
Right, yeah.
Once you hit 15 years, you have rights by adverse possession. St Kilda's very trendy. If it still suits you in 11 years' time, you'll be fine.
But one of the previous owners, the property's been flipped a couple of times in the last, say, 15 years, and one of the previous owners, I believe, has died. So I won't be able to get his assignment of possessory right, or whatever they call it.
No. So you need to look at, but it may well be that you can get, if you go back far enough, you could buy someone else's possessory right. So let's say you've got 4, the one before you had 3, the one before you has since died but only had 2. You might get the whole of your 15 years prior to that person.
Oh,
right.
I thought if there was a gap, then it starts all over
You need
again.
a continuous period of 15 years, but it doesn't have to include any of your time.
Right.
And it needs to be. It needs to have. You need to have got to the 15 years less than 15 years ago.
Right.
All right.
Okay.
Otherwise, those rights are lost. Good luck, Peter.
Okay. Thank you.
Good luck. Hope that's helpful. Peter in Geelong, another one. Good morning. Go ahead.
Hello.
Hi, Peter. Hello.
Hi. How can we help
Peter,
you?
you're there?
This is Peter from Geelong here.
Yeah, go right ahead. You're on the air.
I went into a takeaway for lunch the other day, and they put new prices up, but they had they put new prices up at the counter, but the old price is up on the board.
Yes.
And it's a franchise.
Yep. So it's one of the biggies. Yes.
Yeah. And they sell 6-inch rolls.
Okay. Yes.
So I just wonder if that's legal.
The answer would be, was there confusion? The answer is yes, it is legal. It's very rare. It seems to me only in service stations that the Bowser price meets the displayed price.
But if you go into Woolworths and their price is market, say $5, well, that's what they can't overcharge that.
Well, no, that's their policy. The issue from my point of view is when you went to the counter, there was no misrepresentation, but there was confusion, but there was no misrepresentation as to the price you were being asked to pay. And what I find interesting is that in all of the advertisements for stores of that kind, they talk about in participating restaurants.
Right.
Which I think means that some restaurants might charge slightly different prices.
Okay, so Peter's stuck with that, is he?
Peter's stuck with it. He's probably consumed it anyway. Yep.
Peter, vote with your feet. Go somewhere else where the prices line up. You've got many of options. Good luck. Thanks, mate.
Yeah, thank you.
Thank you. Thanks for calling in. Catherine in Ocean Grove, what's going on?
Yes, thank you. I employed a glazier to replace my windows with double glazing. And he's done an awful job. However, it transpires that he was using a name and an ABN that was not his. It was his partner's.
Yes.
I've been to the domestic building conciliation, and they say they've contacted the partner, who says that she's closed the business. There's no money involved, no money there to do anything.
Yes.
Is there anything I can do other than go to VCAT? Because it seems to me that some of the stuff he's done comes under the unconscionable status in the Victorian building.
Catherine, I think that you have a claim against the person who did the work.
Right.
Now, it may be that that person using his partner's ABN and business name and company name has broken a series of other laws.
Yep.
Where I look at it, you really need to get the identity of the person who represented themselves as being at the business. I would be there is a process in the magistrates court which allows you to issue proceedings before the claim, the glazier claim, if you like, to identify the party. So I
know who it is. Does that?
Well, why would you not have a go at that person? Why would you not issue proceedings at VCAT against the person who actually did the work?
Well, I was going to do both.
That would where I would go. You may need to. The partner was either complicit in the arrangement or didn't rectify it when required. So I would have a go at them, in the same way as if you were involved in a car accident where where an employer owned the vehicle, you can normally sue both the driver and the employer. I would have a go at the person with the business and the person who did the work.
Catherine, just briefly, can you describe why the work is so bad?
Yes, some of the windows have not arrived. They were ordered in October 21. Ones that have been installed inside out, back to front, so that it's heating up rather than cooling.
Virginia, I hate to tell you this, but glazing is side-specific. You've got to put the right glass on the outside.
Oh, gee.
Yeah.
Yep.
Windows that were too big the sills have been hacked away and then covered up with beading to be squeezed in, and now to take them out is going to smash them. So
I'm not surprised about the delay, Catherine, but go for your life. I would have a go at both the person who, it would appear, allowed his or her partner to use their ABN and trading name, as well as the person who did the work.
Catherine, good luck. David is telling you to go for it, so I'd take that as very good advice. Mark in Geelong, I think we've got more building defects. Go ahead.
Hello.
Mark, you're on the air. Good morning.
Thanks, Virginia. My wife and I bought a brand new home unit in Geelong, one of three in the development, about 2 years ago, and almost immediately we moved in, we became aware of defects that were appearing, and they mounted up until there were about 60 of them. And in the interim, the builder went into liquidation, and we made a claim to the builder's insurer, and we're up to about $138,000 worth of remediation works, and we've had to move out for a couple of months. Now, the unit next door sold late last year, and because of the extent of the problems we were having with our unit, I made these problems aware to the agent who was dealing with the sale. And he wasn't interested at all, and I thought that he probably had to... He probably had to divulge it in some way to a potential buyer. So I wrote a registered letter to him explaining all of the problems that we'd had. Of course, heard nothing from him. And the new owner of the property was devastated when I told him, when I became aware of who he was, and was very upset that he hadn't been made aware of this prior to the sale. I'm wondering what position he's in now.
The position is the position of the owner of the property. The owner would appear to have breached Section 12 of the Sale of Land Act. If you can find that Western Australian case, which was decided on the 26th or 29th of May, at ostley.edu.au, Western Australian Supreme Court, and if you search on building defects, there it will be. And you might bring that to the attention of your neighbour.
All right. Yes, he may want to pursue
take it further.
He may not. May not want to, of course.
You might talk to the business licensing authority about whether you consider that's a breach of a professional standard by the estate agent.
Yep. And we'll leave that with you. Mark, good luck. Hope that's helpful. Al, in the northeastern suburbs, what's going on, Al?
Hi, Virginia and David. inquiry is in regard to Victoria Police. There's an ongoing fencing dispute with my neighbour, and we're seeking to get a new fence erected and an existing fence on the correct boundary. Part of the reason for getting a fence is my son has a disability and can run onto their driveway. They are disputing this, and it's going to court. The neighbours have been bullying and intimidating us since we've handed them the fencing notice. As the matter has been progressing, their behaviour has been escalating, and at one stage they've come onto our property and damaged the side of a house where a light is. This was reported to police who attended. At the time, I did not know if there was any damage done, as the area is up high, so police said to let them know if I find any damage.
Yes.
I've looked and there is damage. I got a quote to fix the damage, which is $650. I called up the police station and forwarded the quote. They told me they will not be doing anything about the damage and to just claim it through my insurance.
Yes.
I have asked why nothing will be done, and they refuse to say. I also raised concerns with the police that the neighbour's behaviour is escalating and inquired about a personal safety intervention order. By this stage, the neighbour have been entering our yard several times and throwing our property, swearing, and now using vehicles driving into our driveway or towards our house.
Yep. You can, Al,
to go to court to apply for an order.
You have the ability to make your own application for a personal safety intervention order. My experience is that the police, I've reported a couple of matters to the police recently where I thought there was inappropriate behaviour in relation to the administration of an estate, and I just didn't get to first base. I thought it was theft and got nowhere. And so the police's primary obligation is to maintain the peace,
yes,
rather than protect property. I would be suggesting the first thing I would be doing would be buying some cameras that look at your side of the property, not deliberately into theirs, and apply for your personal safety intervention order yourself.
David, I went to court and applied for an order,
Yes.
which a full interim with exclusion was granted. Cameras have been installed and evidence has been gathered.
Yes.
And the order was sent to the police station for service last Friday.
Yes.
I've now been told that the same police have sent the IVO back to court by post, saying there is an issue with the distance on the order. They're claiming that it's stated not to be within 200 metres from our house instead of 5 metres on the boundary.
Yes.
The court have said that the IVO states to be within their boundary. I called the court and they informed me that this is not true. There is no error on the order.
So what I would be doing, Al, is I would be making probably a contempt application to the magistrates' court, addressing to your neighbours on the basis that they're continuing to breach the terms of the order.
I spoke to the police again and forwarded the correspondence.
I understand that, but you're going to have to run this yourself. You're not getting your assistance from the local police office. You can, if you like, complain about the failure of Victoria Police in this regard, but your starting point ought to be back to the magistrates' court, bring your neighbour back to court.
Al, we'll have to leave it there, but we hope that's useful to you. Thanks so much. George in Keysborough, good morning. George, good morning.
Good morning. How are you, Virginia?
I'm well. Go ahead.
Look, we bought a car from an auction house and went to the mechanic later on, a couple of months later, and then the mechanic advised us the odometer was rolled back.
Yes.
I did not believe him, and he said we can check, and went to a series of websites, and we found the history of this vehicle.
Yep.
And
George, when the auction house acquired the car, they will have recorded the odometer reading at the time they acquired it for sale.
Correct.
If you know that odometer reading is consistent with what was on it when you bought, then the claim, if you like, is from the car owner before, not from the auction house.
Yes, and I've asked them for this information, but they said they cannot give it to us because of BBC Acts.
They can give it to you. I would be Look, I'm wondering whether I'm going to take that one on notice, George. I want to see whether or not the auction house... Was the auction house a registered motorcar trader or just an auction house?
A registered motorcar trader, and also
then be making a complaint to the Business Licensing Authority on the basis of that. They may. Your argument is that what you want is evidence that they didn't misrepresent the vehicle, and that will be there needs to be a consistency between what was on their purchase book and what they displayed it as when they sold it to you.
All right. Hope that's helpful. Thank you so much. Scott in Caulfield. Scott, good morning. What's going on?
Good morning, David in Virginia. Thank you very much. The house I own in Caulfield, I share a driveway with my neighbour next door. The driveway is an easement, and the boundary property goes right down the middle of the driveway.
So you have mutual easements, do you? You've got...
Well, it's just one easement, but it's half on my side, half on theirs.
Then it's two easements.
Okay, it's two easements.
So you've got an easement. You on your side of the driveway, your neighbour has the benefit of an easement on your property, and on your neighbour's side of the property, you have the benefit of an easement. So it's kind of like there's, let's say it's 10 feet wide. There are two easements 5 feet wide, one on each property, is what it will be. Or somebody will own it all, and the other side just has the easement. What's the question?
The question is, we want to get rid of our easement.
Yes.
Now, I don't know whether this is a complicating matter, but no one has lived next door for 22 years. And the person who owns it has recently passed away. And I've asked the relatives if they would be interested in having their easement removed, and they said no. So I was wondering whether there's any way that I can have the easement removed without their agreement.
No. What you've described to me, Scott, is that you have used the easement in a manner that's consistent with its terms. You haven't exercised the rights of the owner in relation to their driveway. So the answer is no, you won't unless you fenced it in. So, and what you might do is look, at the moment you have an easement that gives you both access to your backyards.
So we have two garages.
I understand. Okay, two garages, but if you were to lose the benefit of that easement, that might adversely affect the value of your property. I would be making that inquiry before I did anything else.
Okay. And we'll leave our advice there this morning. We've got a little bit of homework that you've taken away, and I'm at a judgment over in WA that may have ramifications here, which would be very, very interesting.
It will be. Thank
Some
you.
people saying that a noisy neighbour is a temporary problem rather than a permanent one.
Well, I actually saw someone referred to it as temporal.
Temporal, which is not the right use of the word.
No, it's spiritual, I think.
Exactly.
Yes.
Good on you, David. David Whiting there.